Oh, okay. We had our first technical glitch. You can't do one of these with mute on. Good afternoon, everyone. My name is Mike Harrington. I'm a member of North Carolina's Labor and Employment Group. We're going to get started in just a moment. We have folks still signing on, so we're going to wait one more moment, and then we'll dive into personnel documentation. Okay, why don't we get started? As people sign on, they can certainly jump in. But welcome, everyone, and Happy New Year. It's kind of exciting to be having this webinar today because we have over 100 people signed up to listen to the webinar. This is our third webinar for the Labor and Employment Group. And so we are glad that these webinars are being valued by folks, and we will certainly continue to do them. I've mentioned in the past that if you have an idea for a topic that you'd like covered at a webinar, please email us and let us know. We certainly would value any input you can provide. So thank you for joining us today. And everyone is going to be in listen-only mode. If you have a question, you can email it, and I will be glad to answer questions at the end of the presentation. At the end, all of today's participants will receive an email from Jackie Rowe after the seminar with a copy of the PowerPoint presentation and an attendance certificate. So you don't need to worry about that. We will make sure you get a copy. Okay, so with that, let's get started. So we're talking about personnel documentation, and there are basically, trying to move on to the next slide here. Here we go. A couple basic types of files that most human resource departments keep. Obviously, the primary one being the quote-unquote personnel file. And you might have a separate portion of that personnel file be benefit documents, enrollment forms, those kinds of things that once they get filled out, you generally don't have to touch or look at too much. So that's your personnel file, and we'll be certainly talking about that in depth in a few minutes. You have a medical file where you, as the employer, may have certain medical information regarding employees, FMLA paperwork, disability accommodation paperwork, and the idea is that those documents contain very personal information that only people with a need to know should be seeing. Then there's a security file that we'll be talking about in terms of investigations that you may be doing with regard to certain personnel. And then finally, your I-9s, and we'll talk about how those are best kept. So what makes for a well-organized personnel file? You can see one fellow is organized, the other one is not, and we're going to make sure everyone tries to be like the fellow on the right. Just trying to, okay. One thing that's important is, depending on the state you're in, there are state statutes that define what constitutes a personnel file. It is not simply whatever you put in the file. Here in Connecticut, we have a very specific definition of what constitutes a personnel file, so that when an employee requests their personnel file, there are certain documents, even if they are not in the file, that need to be produced so that the statute is complied with. And here are what need to be produced. And basically, it's any and all documents that are being used to make an employment decision about the employee. It could be the decision to hire, discipline, promote, transfer, whatever. If there are documents that are being relied on for those employment decisions, they are going to generally constitute part of the personnel file. Our statute explicitly provides that certain documents are not part of a personnel file, including some stock options, bonus plan documents, anything maintained in security files, and we'll talk about that definition in a bit, test information. So there are certain things that the employee that may involve an employee, but do not come within the definition of personnel file. Medical records, as we talked about just a moment ago, are those documents that contain some sort of medical information, either regarding the physical or mental health of the employee, which an employer relies on to make an employment decision. It's important that medical records are not put into a personnel file. The general belief is that a personnel file is a working file. Supervisors may or may not need to look at a personnel file in terms of transferring or issuing discipline or making some other decisions, but those supervisors may not necessarily need to be involved with the medical information of their employee, and in many regards it's best to keep supervisors not in the loop with regard to pertinent medical information unless it really impacts the job. So you want to have limited access to a medical record with regard to only those folks who need the medical information. And then there's security files. Now, the important thing about security files is it cannot contain information on which an employment decision is being used. So once the investigation's concluded, once a final decision is made, then those documents that are used to make that decision are going to fall into the general personnel file definition here in Connecticut. Now, that's not to say that you necessarily need to drop all of those documents into the personnel file, the hard file. You might keep those separately because it's now been dealt with in terms of your witness statements and what have you. But just know that if a request is made for that personnel file, you may have to produce those underlying documents. Now, it's important to realize that the personnel file shouldn't just be the depository of any and everything that deals with an employee. It is important, and we'll talk about some of the important and typical documents you should have there, but documents that go in there should serve a very specific purpose, and if they don't, then they probably should be removed. The other thing I want to note, I don't have a slide about it, but in my years of practice, I've certainly come to appreciate that sometimes supervisors have what might be called a shadow file, a supervisor's file, and those files may contain documents that the Human Resource Department does not have, but which nevertheless qualify as personnel file documents. So if a request is made for a personnel file, you may have to seek out an employee supervisor and ask, do they have any particular documents related to that individual's employment? And you may encourage supervisors not to keep those files themselves because certainly I'm familiar with situations where supervisors have not kept those files in a confidential manner. They haven't kept them under lock and key, and you would hate to have some inadvertent disclosure or publication of those documents. So what should be in a personnel file? I don't think anything on this list is going to be a surprise to anyone, but you want the job description, the job application, resume, any offers of employment, tax forms. If there's a handbook that's been signed for, you want a copy of that in the personnel file. Evaluations, forms that relate to benefits. As I mentioned, you might segregate those in a subsection of the personnel file. Any emergency contact information. And then with regard to any specific feedback on which an employment decision has been made. So if there have been complaints brought against the employee, or if there's accolades or positive comments which are used to inform a person's employment, those may all be included, as well as certain attendance records, warnings, or disciplines. then as well, if the employee has any contracts, written contracts, acknowledgments, if there's been a document, say, to recover advanced vacation paid, and the employee has agreed that if they leave at the end of their employment without earning that advanced vacation, that the employer can recover it, that would be appropriately placed in the personnel file. And certainly any documents related to the employee's departure, documents that would support why a termination decision might have been made or a resignation letter that was submitted, and any unemployment documents that might follow from that. Those are all the types of documents that should be in personnel files. Over the years, I've received personnel files that have been a hodgepodge of documents, not in any particular order. Some of them are rogue emails that didn't necessarily result in any employment action being taken. So periodically, you may want to do audits of your personnel files and make sure they're in good order. When it comes to I-9s, certainly this is a document that's required for all employees, but the best practice here is to keep them separate from personnel files, and the main reason is you may be called upon by ICE, which is the government agency responsible for auditing I-9s, to produce your I-9s for your entire workforce. And if you had to go through all your employee personnel files, pulling those out, it could be rather cumbersome. So a good practice is to have your I-9s in alphabetical order in one place, and as employees leave, you might put them to another location. We're going to talk in a little bit about the retention requirements, but have your active employees in one place and your inactive former employees in a different place for as long as you need to keep those documents. Okay. In terms of access to personnel files, it's important to appreciate that most states, including Connecticut and Massachusetts, do provide for employees to have access of their both personnel file and their medical files. Now, a couple things surrounding that. The employer may require that the inspection of the personnel file or the medical file be done in the presence of a designated officer. The employee does not have a right to take their original personnel file home or even to their office. They do have a right to a copy of it if they want, and a reasonable charge may be imposed on that. But if they simply want to look through their file, you can decide that you want that done in the presence of a designated officer, and that may not be a bad practice to have. Employers can limit the inspection to twice a year. You don't have to do that, but if you have someone who is frequently asking to see their file for no particular reason, you could rely on this statute for limiting that. Okay, so when must you provide for it? There's 2 years ago, maybe 3 now, 2013 I believe, we had a new statute imposed in Connecticut which addressed the time periods that people have a right to see their personnel file in. So for current employees, within 7 days of getting the request, you're to make the file available or provide a copy. If it's a former employee, for up to a year after separation, you need to produce the file within 10 days. Now, this is a brand new rule that I think some folks are still getting used to and implementing. When you provide a copy of, when there is documentation of disciplinary action, the employer now in Connecticut must provide a copy within 1 day of that action being imposed. Certainly folks with unionized workforces probably have lived with this kind of policy and procedure. I think it's a good one as a general rule, because if you go through the effort of writing up a document, in order to issue some action or take action in the future, you want to make sure the employee understands the importance of it, and that's best communicated by giving them a copy of it. And by doing so, it certainly prohibits them from later claiming that they were unaware of the documentation or that the issue had never been addressed with them. So now you just need to do it very promptly, but I think it's a good practice that will serve employers well. If there's a written documentation of termination, that must be provided to the employee immediately. Now, the statute didn't go so far as to mandate employers to write up any particular types of documents. Simply requires that if there is a written document, then it must be provided to the employee. You might get into a practice of having employees sign a copy confirming receipt. Sometimes frequently, employees refuse to sign. That's fine. You don't need to get into a wrestling match over it. Simply note that the employee refused to sign and date, make a notation of the date on which that occurred. Okay. When we talk about personnel files, frequently the question comes up is, to whom may that file be disclosed? In terms of disclosing the file outside the organization, it's generally prohibited. Most states do have statutory prohibitions against disclosures with certain caveats. And so here I outlined the caveats in the Connecticut statute. They should all make general sense to you. Certainly a third party that works with the employer, they can receive the documents without written consent from the employee. If you've been subpoenaed for documents before this webinar, I had a client forward to me a subpoena, which is common in the sense of employees who are involved in a divorce. One of the documents that will be requested for purposes of processing the divorce will be wage information. So you don't need employees' consent once you get a subpoena for that type of information. If there's a summons issued by a law enforcement agency, you can produce that. But just know the general rule is you should not be disclosing personnel information or medical information without fitting into one of these categories. Okay, one of the new developments that came in that statute is the ability to, and employees always had this ability, I should say, here in Connecticut, that if they didn't agree with something in an evaluation or in a disciplinary notice, they had the ability to write a statement from their perspective as to what they disagreed with. Now, the new change is that you have to tell employees that they have this right. Again, this is sometimes very helpful to employers from preventing employees subsequently coming up with a different version of events. So if an employee has a different recollection of what has occurred or a certain piece of information that they think is important to the situation being discussed, they have that opportunity promptly to provide it to the employer. There's certainly a possibility that if you receive that information, you might reconsider whether the discipline or the evaluation is appropriate, or it might confirm what you already knew and confirm your decision. But be that as it may, I've seen employers now produce documents, blank documents or form documents, which would have this language right on them. And so if you don't have that, you might think about adding that, or if you don't have standard form documents, just know that when you write up a warning, some sort of communication to the employee of a disciplinary nature or of a review, that it has to state in clear and conspicuous language that they can submit a written statement in rebuttal if they wish. Okay. Just want to talk a little bit about evaluating performance and documentation. concerns in that regard. Certainly evaluating an employee's performance is a very important activity. I think it is sometimes an activity that doesn't get the attention that it deserves. When giving feedback on someone's performance, to the extent that feedback can be timely, that certainly makes the feedback more beneficial. But also, feedback should be as specific as possible. Generic type of feedback has very limited value. And the more specific feedback can be, the better. I saw this cartoon and thought it was good, you know. And sometimes that is the nature of the feedback that folks get, simply like, you know, 2 thumbs up, you're doing fine, without any specifics in terms of what are they doing to make sure they keep doing what they are doing well and repeat that, as well as areas they might improve upon. Certainly when you give a review or you give feedback, it should be as truthful and candid as possible. In terms of being factual, sometimes folks find it very difficult to give honest feedback, and so the feedback is diluted or sugar-coated, and that becomes a problem usually later on. One, the employee doesn't fully appreciate the concern that might be present, and subsequently, when there's a final straw that breaks the camel's back and the employer really can't tolerate the performance that's been going on, the feedback that precedes that decision certainly wouldn't lead someone to believe that there was a concern. And so, in fairness of giving the employee honest feedback and putting them on notice about things that need to change, otherwise their job may be in jeopardy, is important. Okay, and certainly these are the reasons why honest feedback is important. Not only does it protect the employer in that it's giving honest feedback to an employee about what's going on in the employer's perception of it, and it gives both the employer and the employee an opportunity to discuss that concern. It puts the employee on notice as to the issue, and then it serves as a document of the reality of the situation. I certainly have had the occurrence, far more times than I like, when there's been a lawsuit, usually a claim of discrimination in one form or another, and I'm looking through, and I've heard from the employer that there were a number of concerns with an employee, and then I get the personnel file, and I'm looking through the personnel file, and my take from the personnel file is the employee wasn't that bad. The employee got generally positive reviews. There's no write-ups, no counselings. There's nothing to suggest in writing that there were concerns with the employee. And those types of cases become very difficult to defend because both the agencies that look at these cases, the CHRO or the EOC or the MCAD up in Massachusetts, as well as juries, believe that if there was truly a matter of concern that the employer had, they should have put it in writing and put the employee on notice. So failure to document generally hurts the employer in those cases. Okay. When it comes to investigatory documents, it's important that the documents that you might have answer those basic questions: the who, the what, the when, the where, the why, in terms of what has occurred. And if they don't, then you should ask yourself whether there should be some further efforts made to investigate whatever's being looked at and to clarify the document. Whatever documents you have as a result of an investigation, you want to make sure they are clear and they are legible, such that a third party might be able to look at the document and follow what is trying to be conveyed in the document. I had a very unfortunate case this summer where an investigation was done and the notes created by the supervisor were absolutely unintelligible almost illegible. And I didn't put them in to evidence, but the union did. And the union used these notes to basically show that the supervisor had a very haphazard way of trying to investigate the matter. So as HR folks, you may be directly involved in doing the investigation, or you may be supporting supervisors in conducting their investigation. When you get those documents in the write-ups or the witness statements, first you want to make sure you can read them. If you can't read them, they're going to have limited value. And then you want to make sure that they are understandable, that they convey either what statements a person made or what evidence was found. And if not, before a final decision is made, then you should send that document back to the person who created it and direct them to produce a document that is legible and is understandable. For some folks, their penmanship is just not legible, and so those documents may need to be typed and then signed. But at the end of the day, there's no sense having documentation that can't be read and understood. Okay. Now, this is a good lead-in for our final topic is, after you have all these documents, how long do you have to keep them? And before we go through this list, let me first say that, because there was a person who sent in a question earlier before the presentation about electronic documents. Certainly, the world is headed to electronic documents in general. Court systems now have electronic filing as a matter of course, and certainly HR departments are free to utilize the technology that's out there for maintaining documents electronically. And in some organizations, it's really the best way to keep documents because there may be people off-site who have supervisory roles, and so accessing an electronic file is much easier than having someone pull a hard copy and scanning it to them. But with everything, there's a pro and a con. So the pro is certainly electronic documents are valuable, they are versatile, they don't take up space, but you have to be cautious in terms of who has access, how secure is the system, and making sure that there is a backup. And it is true that fires occur in buildings and paper documents could be destroyed, but I think experience shows that electronic documents probably have a greater likelihood, or had a greater likelihood before certain provisions were put in place, about being destroyed or not being able to be produced. At the end of the day, whatever documents you have electronically, you have to be able to produce them in hard copy if an agency is looking for them or if an individual is looking for them. So with those caveats, I think electronic documents are the wave of the future. You just need to make sure that they are securely maintained in an appropriate way, just like they would in a hard paper fashion. Now, in terms of retention documents, you can see from this chart, there is requirements all over the board, mainly because you have different statutes, you have different potential causes of action at play, you have state law interacting with federal law. As a general matter, if you were looking, I think one thing you might want to use as an outside rule is the longest statute of limitations possible, and keep your documents for that period of time if you wanted a one general bright line rule. And as you can see from this chart, the ERISA documents, documents related to benefits, are required for 6 years. And that happens to dovetail with most states' statute of limitations for contract claims is generally 6 years. It's the longest statute of limitations typically pled in the employment context. You do have shorter statute retention requirements, I'm sorry, for some of these other claims. So you're certainly free to discard documents earlier if they fall into those categories. What I would remind folks is the minute an organization receives notice of a threat of litigation, not necessarily the actual lawsuit or actual administrative claim, but the threat of litigation, the organization should make sure that it issues a hold on all relevant documents. Most lawyers, as a matter of course now, the minute they enter a case, are entering these hold letters to their clients, reminding them of this obligation. But the concern is, especially with electronic documents or maybe organizations that have purging schedules, that relevant documents could be destroyed, either deliberately or inadvertently. And regardless of whether the destruction is deliberate or inadvertent, most courts will apply an adverse inference against the party that destroys potentially relevant documents. And so you don't want to be in that situation. So just be aware that the moment a threat of litigation occurs, that the organization take active steps to make sure that relevant documents are segregated and preserved so that you don't find yourself in that situation. Okay, with that, let's just check to see if there are any questions. Give us one moment. Okay, for the moment there are no questions. Oh, I'm sorry, there. Okay. Okay, so the question is, where should you keep your EOC documents? So I would keep them in a specific file designated your EOC. So if you're EO1 and other affirmative action filing documents, I would not keep them in any personnel file because they are more global to your workforce. And you should also keep them under, secured under lock and key along with your other documents. In terms of keeping them, I believe, so under our schedule, if what we're talking about is some affirmative action related EOC documents, those are required to be kept for 2 years. If there are documents related to any particular cases going on, then you can't destroy until the case is over. Okay. So the next question deals with workers' comp claims and files. So separate and apart from your injury log, which also would tie into your OSHA 300 log, if you have individual claims by an employee of a work-related injury, those should go into the medical file. Your medical file might have subcategories, workers' comp versus FMLA versus ADA, and that's fine, but those forms do relate to medical information of an employee and should be kept in the medical file with limited access to only those people who need to know. The next question is, do employees need to give written consent to share information with insurance companies when they've claimed an injury? No. The insurance companies are considered a third party and they fit in within the exemption from meeting specific requests. If you have any parties who are basically acting as your agent in some regard, a payroll company, some people have vendors to assist with their HR services, or insurance carriers, those all fit within that exception. In terms of original signatures, an electronic signature is generally fine. It depends what the protocol is to sort of ensure that that signature reflects the employee taking some action as opposed to maybe somebody else doing it on their behalf. So, you know, I personally like original signatures because they really are the best evidence that someone did sign. Everyone's got a very unique signature, but there are no specific laws within the general realm of employment documents that do not allow an electronic signature. Certainly, electronic signatures are becoming more the norm in our society, and they'll probably become more the norm in the HR world as well. Just a minute. There's a few more questions. Sample language. So I don't have sample language because really all you need to do is take whatever form you use and add language that simply says you have the right, let me get back to our slide here, you have the right to file any statement you know, contesting anything you disagree with, something along those lines. But let me just get back there. When you get to the PowerPoint that's going to be sent out to you, you just need to inform that if the employee disagrees with anything in the review or the discipline, that he or she can submit a written statement in response. Doesn't need to say anything more than that. Changing, the question is there a need to keep the paper documents approving a change in employees' hours pay? Or is the change electronically that indicates reason enough? I guess that may be a little individually specific, case specific. If there is a change being requested by an employee, and you want to make sure that that's preserved in that who requested the change, that I would want to keep. For example, in some circumstances where employees have brought harassment complaints, quote-unquote harassment complaints against an employee, some of those situations have been resolved by employees being separated and then one employee being transferred. And in those particular cases, you want to make sure that especially the person bringing the complaint isn't being transferred as a form of retaliation for bringing the complaint. But in many circumstances I've been involved with, the employee requests that change, and you would want to preserve that as evidence of who made the request. If it's a general January 1, you're getting a 3% increase, that's less important. It's probably dictated by some general memo you're going to have or a collective bargaining agreement, and so you wouldn't need anything beyond the payroll document to reflect that. There's a question, when you refer to the medical files, is it a general medical file for all employees or employee specific? It's employee specific. So for each employee, and there may be employees that don't have a medical file. You know, folks that never get injured, never make an FMLA request, never request an accommodation. Those are the types of documents you would keep in a medical file. But if an employee has those kinds of documents, you should create a medical file. As a best practice, most employers treat those files in a different color to the extent they're kept in hard copy. Red seems to be a popular color for medical files, but certainly, you know, you can choose whatever system works for you. But it's the idea that those documents related to a particular employee are segregated from the employee's general personnel file so that only the people with the need to see that medical information have access to it. And yes, there's been a question about will this presentation be available for replay? Yes, there should be a link on our website, and it will be emailed to all people so that if you want other individuals in your organization to listen to this presentation, you should be able to do so. If you have any problems with that, please let us know. Like I said, this is a new endeavor for us, and so we are constantly trying to make sure we improve on on how it works smoothly for folks. And then there's a question, if a situation in which one staff member writes a letter to a supervisor about another staff member and the other staff member submits a written statement, should it be filed in both employees' files? Again, this is a little case-specific, I would say. It depends on the nature of whether there's an investigation and ultimately whether there's any action taken. If there is no action taken against either employee other than, very simple, sort of, is there anything going on here, you may keep that in your investigatory file. If there's specific action that is taken, someone's disciplined, counseled, then you may want to attach that complaint because it informs what the nature of the issue was that led to that. So those are the general principles that you might use to decide whether to keep that or not. And also you may think about whether that complaint is made anonymously, whether the identity of the individual needs to be revealed to the person or not. Again, I could imagine a whole lot of situations where, depending on the facts, you may or may not be revealing the identity. And certainly if you don't reveal the identity, you wouldn't want to include that letter in the employee's personnel file who's being complained about. Are there consequences for not advising an employee of their right to submit a rebuttal? The statute, I didn't bring up a copy. I do believe it contains a fine for doing it, and I just cannot recall off the top of my head what that fine is. But I do believe it's a fine. My recollection is it's a couple $100 per occurrence. But without looking at the statute, I couldn't tell you for absolute certain. But again, not only is there that fine, but I do think there's a benefit to the employer for saying to the employee, do you have something, if you have a different perspective, if you have, some statement you want to have me see, and they don't do it, then I think there's a fair inference that can be taken that they somewhat acknowledged the facts as the employer understood it for issuing the discipline. So I think it is a good practice, separate and apart from the fine that I believe the statute would impose. Wait one more minute. I think that was the last question asked, and it is about 1:15, and that's our target for these. I really appreciate you joining us today. Our next presentation will be in February. It's going to be February 10th. It's going to be dealing with transgender employees in the workplace. We hope you can enjoy it and join us. If you can't join us, then there will be a link, so look for it sometime after February 10th. If you have any other questions about personnel files, feel free to reach out to me or one of the other members of our Labor and Employment Group, and hope everyone enjoys the weekend. Thank you.